Good morning.
Good morning, everybody. It is I call the time is 10 o'clock. I'll call the January 16, 2025 Planning Board meeting to order. We're joined by our Vice Chair, Ms. Bailey. Good morning.
Good morning.
We have Commissioner Giraldo.
Good morning. Okay, I've added it.
Sorry, that was Siri on my other computer. Hold on one sec. And Commissioner Washington.
Good morning.
Good morning, and I'm Chair Shapiro. Moving forward to the business at hand, to remind folks, please note that the deadline for all participant pre-registration and submission of materials and exhibits was, as always, was 12 noon on the Tuesday before this planning board meeting. Registered speakers can join the meeting with a link provided in the email that is provided by the planning board office. Of course, anyone can tune in to watch our meetings via live stream. If you wish to speak or become a person of record, you'll see the process laid out before you on the screen. In addition to our commissioners, we are joined by our senior counsel, Ms. Coleman. Good morning, Ms. Coleman. We have Jessica Jones, our planning board administrator, Rhonda Ford, our technical hearing writer, and Sherry Connor, the acting development review division chief. Good morning. We also have Mr. Flanagan and Mr. Connor helping us with technology behind the scenes. The order of cases, colleagues, we're going to have one shift. We're going to take item 7 at the end of our regular agenda items. Other than that, everything will follow in due course. So item 2 on our agenda, I'd look for a motion to approve the draft minutes from January 9, 2025.
So move.
Draft. Second.
Got a motion by Commissioner Giraldo, a second by Vice Chair Bailey. If there's no discussion, I'll call the roll. Commissioner Giraldo.
I vote aye.
Vice Chair Bailey.
But I.
Commissioner Washington.
Vote aye.
I vote aye as well. The ayes have it 4-0. There are no legislative items this week. We're now going to go into executive session. For the public, it'll probably be about 15 minutes, I would say, at the tops. And colleagues, note that it's one executive session, but we're going into 2 separate links. So please note that the first part of the executive session is one link, and then we're going to close out that one, drop into the other. It's all one executive session, but for logistical reasons, please note that. Pursuant to the general provisions article of the Annotated Code of Maryland, Article 3-305, subsections B1I, B3, B7, and 13, a closed session is proposed to discuss a personnel matter concerning an appointed position in the planning department, the acquisition of real property for a public purpose and matters related thereto, and for the purpose of protecting the commission's negotiating position. That is it. We had a third item that we're going to take up in executive session. We're not going to do that. So it's just those 2 items.
Excuse me, Mr. Chair, just confirming that that's going to be subsection 7 and 13 that is no longer on the executive session agenda.
Okay, thanks for clarifying that. Appreciate that.
Thank you.
So that is why we're going into executive session. I'd look for a motion to go into executive session.
So move.
Okay.
A motion by Commissioner Giraldo, second by Commissioner Washington. With no discussion, I will call the roll. Commissioner Giraldo.
Aye.
Commissioner Washington.
Vote aye.
Vice Chair Bailey.
But I.
Vote aye as well. The ayes have it 4-0. All right. For those for whom it is pertinent, we'll see you in the first executive session, and we'll see you back in the public in about 15 minutes or so. Commissioners, we're good to go, team?
Yes, we are good to go.
Okay, thank you. We're back in open session from a brief closed session. In closed session, we gave consent to staff related to some property acquisition. Let's move on with our agenda. We're now on item 3C on our agenda. We have 2 Parks and Rec items, actually, items 3C and 3D. In both cases, Mr. Sun will be giving the staff presentations. These are both action items, and we will start with item 3C, Andrews Manor Park. Mr. Sun, the floor is yours.
Good morning, Chair Shapiro. Can you hear me?
Yes, sir. Okay? Yep, we can hear you fine.
Good morning, Chair Shapiro, fellow planning board members. For the record, my name is Paul Sun, Land Acquisition Specialist, Department of Parks and Recreation. Next slide, please. We're here today to request approval of grant of easement for access and utilities at our Andrews Manor Park. The park is generally located in the Suitland area on the south side of the Capitol Beltway, approximately 600 feet east of the intersection of Oth Road and Medford Avenue. Next slide, please. The existing park is currently undeveloped, and access to our park is via an existing ingress-egress easement that we have with the adjacent Beltway Church of Christ. Additionally, there is a WSSE, Washington Suburban Sanitary Commission easement that runs a length of the property along the Capitol Beltway frontage. Next slide, please. In November of 2023, the Planning Board heard a mandatory referral case for development of a solar field by Synergen Manchester. Next slide. So that mandatory referral is to the southwest of our park. Here it's outlined in orange. And there is a need for access through our park for their future solar activities. Synergen Manchester has obtained a easement from the church, which follows our ingress-egress. And they're requesting access easement along the WSSC right-of-way that we have. The easement will be roughly 3/4 of an acre, and we find that this will have no adverse impacts to our future park activities. Next slide, please. The easement will be for 25 years and 6 months with 2 5-year renewal options, which is similar to their solar field lease terms. Synergen Manchester has agreed to compensate the commission the average market value of the land area for the granting of the easement. Lastly, since the easement will follow the WSSC easement, we have asked that they obtain consent from WSSC for their activities. Next slide, please. DPR staff recommends approval for the granting of this easement, and note that final approval will be subject by the full commission. Are there any questions?
Yeah, I have a question. So, do we know what the value is of the easement, and is that paid in a lump sum or is that paid yearly? How does that work?
It's paid lump sum. It's just an average of the fair market value of roughly 3/4 of an acre of land.
Okay, and you paid, and so it's not a continuing payment. It's
No, we
how do
did
we
not.
value it? If it's for 25 years, wouldn't the easement be more expensive in 10 years than it is at the present value?
Yes, that is true. We did not agree to the proposal, unfortunately, that way. We just valued for 1 acre of land, the fair market price. That was the way we were set up.
Is that typical?
It is. It is one way of doing it. We appraise the value is, for a permanent easement, it's 90% of the appraised value. Typically, is what we use.
Okay. All right. Thank you, Mr. Sun.
Thank you. Other questions for staff? If there are none, then this is an action item. Staff is looking for us to approve this. Is there a motion?
Move approval, Mr. Chairman, of the grant of access and utility easement for Andrews Manor Park.
Second.
Got a motion by Commissioner Washington and a second by Commissioner Giraldo with no discussion. I will call the roll. Commissioner Washington.
I vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Mute.
She votes aye. And I vote aye as well. The ayes have it 4-0.
Aye.
Thank you. Move on to item 3D on our agenda. And now I have a double aye. Item 3D on our agenda, Rose Creek Connector Trail, Mr. Sun. And I believe we have folks on the line if we have any questions for them too. But let's start with staff.
Good morning again, Chair Shapiro, Paul Sun, Land Acquisition Specialist, Department of Parks and Recreation. We have a request today for approval of a storm drain and stormwater management easement, a Rose Creek Connector Trail Park property. Next slide, please. The property is located at 7201 Calm Retreat Boulevard, which is generally in the Brandywine area, approximately half-mile west of Maryland Route 5 on Calm Retreat Boulevard. Next slide, please. In December of 2020, the Planning Board approved preliminary plan of subdivision 4-19024 for a mixed-use development. Next slide, please. 3.26 acres of parkland dedication was required from the developer, and the developer has done that, which is the subject of our discussion today. Next slide, please. Additionally, as part of the approvals for the proposed development, the developer entered into a recreational facilities agreement, RFA, to develop park facilities on the dedicated land. Items to be constructed include open play recreational lawn, a 1,000-foot extension of the Rose Creek Connector Trail, central plaza with benches, picnic tables, and landscaping. As shown, here's a schematic of the plaza area of the park. Next slide. And here's the southern portion of the park, as it connects to our the existing Rose Creek Connector Trail. Next slide. As you can imagine, there's a lot of infrastructure needed for this development, and trying to fit a park into this development. And Prince George's County is requiring easements for the storm drain and stormwater management system that is proposed. Approval of the easements would allow the development to stay on schedule and allow them to provide this public park. So next slide, please. Here's a more detailed schematic. It's showing the storm drain easements in 7 parts in green, totaling about a half an acre. The stormwater management easements in 2 parts in blue, totaling about 1.3 acres. There's no cost considerations for granting these easements, as the developer is providing a great benefit to the department and to MNC PPC. Next slide, please. DPR staff recommends to the Planning Board approval for the granting of these easements. And please note, it's subject to the final approval by the full commission. Are there any questions?
Alex, questions for staff?
No.
Okay. I think it's fairly straightforward. Sounds like good work. If there's no further questions for staff, then what is your pleasure on this item, Commissioners?
Mr. Chairman, I move that we approve the grant of storm drain and stormwater management easements for Rose Creek Connector Trail Park.
Second.
On a motion by Commissioner Washington, a second by Vice Chair Bailey. Is there any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Giraldo.
I vote aye.
I vote aye as well. The ayes have it 4-0. Okay, thanks, team. Much appreciated. Good work, all.
Thank you.
We'll now move on to our consent agenda. Are there anyone from the public or any board members who wish to oppose staff's recommendations or discuss items 4B and D on our consent agenda? If not, I would look for a motion.
Mr. Chair, After consideration of records for items number 4B and 4D, I move adoption of the staff findings and approval of these items on the consent agenda in accordance with the recommendation of staff.
Second.
Second. Oh,
Motion by Vice Chair Bailey, a second by Commissioner Giraldo. Is there a discussion on the motion? Seeing none, I'll call the roll. Vice Chair Bailey?
Vote aye.
Commissioner Giraldo?
I vote aye, Mr. Chair.
Commissioner Washington?
vote aye.
I vote aye as well. The ayes have it 4-0. All right, we'll move on to our regular agenda items. Again, we will take them up as listed on the agenda, with one exception, which is item 7 is going to be the last one. So we'll start with item 5 on our agenda. This is a detailed site plan, DET 2022-020 McKendree Road. Mr. Tedesco is representing the applicant. Mr. Meyerholtz will be giving the staff presentation. This is an evidentiary hearing, so if we are requiring folks, if folks are going to be providing testimony, they'll need to take an oath at that time. We will start with the staff presentation. Mr. Meyerholtz.
Good morning, Mr. Chairman and members of the Planning Board. Quick sound check.
Yes, we can hear you fine, thanks.
Excellent. For the record, I am David Meyerholtz with the Urban Design section. Item number 5 is detailed site plan DET-2022-020, which proposes 79 single-family attached townhouse dwelling units with associated infrastructure and recreation facilities, including the master-planned Timothy Branch Trail. The site is located on the north side of McKendree Road, approximately 400 feet west of its intersection with Robert S. Crane Highway. As part of the application, the applicant has requested alternative compliance from the requirements of sections 4.6 and 4.10 of the 2018 Prince George's County Landscape Manual. Staff has not received any letters of opposition to this application, and based on this evaluation and analysis, Urban Design staff recommend that the Planning Board adopt the findings of this report and approve detailed site plan DET-2022-020, alternative compliance ACL-2024-003, and Type 2 Tree Conservation Plan TCP2-043-2024. Subject to the recommended conditions of approval within the technical staff report. This concludes staff's presentation, and thank you.
Thank you, Mr. Meyerholtz. Commissioners, any questions for staff at this point? Seeing none, we'll turn to the applicant, see if Mr. Tedesco has anything bright and witty to add on this subject.
Good morning, Mr. Chairman, members of the Planning Board. For the record, Matthew Tedesco here with Dominic Lockhart on behalf of the applicant, Christopher Land, LLC. Also with us, we have representatives of Charles P. Johnson Associates, Brian Hargis, Jason Dunlop, and Phil Hughes. Mike Lenhart is our traffic engineer, and although not with us this morning, helping with outreach and other efforts is the GS Proctor and Associates team. Want to thank Mr. Meyerholtz for his review and staff's review of this application. I think this was my second case with Mr. Meyerholtz, and a very good working experience reviewing this application. Both his team and our team worked collaboratively on this. You have a staff report before you that we have no requested modifications or edits. We are in agreement with the recommended findings and recommended conditions of approval. Just 2 seconds. This property was comprehensively rezoned from the prior CM and RR zones to the RT zone, residential townhouse zone, under the prior zoning ordinance as part of the 2013 Subregion 5 master plan. So this is, as well as the property to the south, really an implementation of the planning goals and policies for this area, to include the master plan Timothy Branch Trail that Mr. Meyerholtz referenced, which will be constructed as part of this development. In addition, the applicant is required to provide and dedicate or convey about 4.62 acres to the Parks Department for parkland dedication as part of this project, resulting in about 49% of the site gross track area remaining as open space, which is more than double the requirement. So all the rest of the information, I think, is sufficiently and adequately provided in your staff report. We certainly agree with it. We submit on our justification statement, as well as all the other materials submitted with this DET, and respectfully request the planning board's approval of this detailed site plan. This is, as I mentioned at the time of the preliminary plan, Christopher Land LLC, which is a Virginia-based home building company. This is their first project in Prince George's County, so we're very happy to have them, and hopefully with your support, facilitate the development of this property as envisioned by the master plan. And with that, Mr. Chairman, members of the board, again, thanks staff for its review, and hopefully thank you for your approval of this application.
Thank you, Mr. Tedesco. Much appreciated. Commissioners, any questions for the applicant on this project?
Only question I have,
Yes.
Mr. Chair,
Sir.
I may have missed it, and if so, I apologize. Is the developer going to put any dog waste stations?
Yeah, you know what, Commissioner Gerardo, I had that in my notes, and just in the interest of time, I neglected to go through it. But on page 2, which I just flipped over, condition 1A requires the inclusion of dog waste stations at amenity sites and along the master plan trail. So that has been provided or will be provided and covered as part of the conditions of approval.
Okay. Thank you, Mr. Tedesco.
Yes, sir.
No further questions for me.
Okay, thank you very much. If there's no further questions, there's no one who signed up to speak, I will close this public hearing. And colleagues, if there's no deliberation, what's your pleasure in this item?
Mr. Chairman, I move that we adopt the findings of staff and approve DET-2022-020, ACL-2024-003, and TCP2-043-2024, subject to the conditions as outlined in staff's report.
Second.
We've got a motion by Commissioner Washington, a second by Vice Chair Bailey. Is there discussion on the motion? Seeing none, I will call the roll. Commissioner Washington?
Vote aye.
Vice Chair Bailey?
Vote aye.
Commissioner Geraldo?
Vote aye, Mr. Chair.
I vote aye as well. The ayes have it 4-0. Thank you, Mr. Tedesco and team, and thank you, Mr. Meyerholtz.
Thank you.
We'll move on to item 6 on our agenda. This is detailed site plan DSP 13008-02, Gilpin Property Phase 3. Again, Mr. Tedesco is representing the applicant. Mr. Cofield will be giving the staff presentation. This also is an evidentiary hearing. If and when appropriate, I'll swear folks in. I believe we have anyone signed up to speak. No opposition on this either. We'll turn to staff for a brief presentation. Mr. Cofield, good morning. The floor is yours.
Morning. Can you hear me okay? Great. Good morning, Mr. Chair and members of the Planning Board. For the record, I am Dexter Cofield with the Urban Design Section. Item number 6 is detailed site plan, DSP-13008-02, Gilpin Property Phase 3, which requests to develop the property with a 115,364 square foot building for a consolidated storage use, providing 1,103 new storage units. The site will have a total of 24 parking spaces and 5 loading spaces located along the perimeter of the building. This is the third building to be added to the southern end of the property, which already includes 2 existing consolidated storage buildings. As a matter of housekeeping, prior to the January 4th noon deadline, staff received a document from the applicant entitled Applicant's Exhibit 1, which provides factual corrections to the proposed number of units, proposed amount of parking, and proposed number of stories of the building. Staff agrees with the revisions presented in Applicant's Exhibit 1. With that, the Urban Design staff recommends that the Planning Board adopt the findings of this report and approve detailed site plan DSP-13008-02 and Type 2 Tree Conservation Plan TCP2-018-13-02 due to the recommended conditions of approval within the technical staff report as amended by Applicant's Exhibit 1. This concludes staff's presentation. Thank you.
Thank you, Mr. Cofield. Commissioners, questions for staff at this point? No questions. We'll turn to the applicant, Mr. Tedesco. Good morning again, and take it away.
Good morning again, Mr. Chairman, and thank you for the record, Matthew Tedesco at the law firm Matthew Murphy. Here on behalf, along with Dominic Lockhart, Arkland Property Company, LLC. With us, we have our consulting team made up of Bowler Engineering, Mr. Nick Speech, our architect from BWD Architects, Rebecca Brown, and Mike Lenhart is our traffic engineer associated with this project. Certainly want to thank Mr. Cofield and the Urban team, which really framed the basis for not only the detailed site plan, the location of this third building, but also preservation of the primary management areas, resulting in the request that you have before you. This is a continuation of a project that really dates back more than 10 years, back to 2013 and 14, for which two previous detailed site plans were approved, as well as the preliminary plan of subdivision. This third building,
I believe we had to reboot the system, so it's going to take a few minutes while folks sign back in. All right, when we start up again, which will be in just a minute or two, Mr. Tedesco, I'm going to need to ask you to give your presentation again, just to make sure that it is on the record. But give us another minute or two to make sure we can get everybody's gathered. Jessica, are you in contact with Commissioners Washington and Vice Chair Bailey by any chance?
I just hung up with Commissioner Bailey. I'm going to call Commissioner Washington now.
Okay, thanks. Thanks for being on it.
Chair, I'm going straight to voicemail, so I'm going to try to send her out a text message.
Okay. Ms. Bailey, we can see you. Can you see us? Good. You're on mute, but it sounds like we're all back in business.
Yep, I can see you.
Okay, great. Excellent. Now we're just waiting for Commissioner Washington, and then we can start up again.
Excuse me, Commissioner Giraldo, do you mind if we do a mic check? I just want to make sure his mic's working.
Hello.
Okay, perfect. Thank you.
What would you prefer I sing?
Try singing. Try singing. I'd love to hear it.
Thank you.
Maybe Ms. Bailey, maybe he can compete in the teen cotillion for Department of Parks and Recreation. What do you think?
I think that would be great if he did.
Team, we're still having technical issues with Commissioner Washington. We have a quorum. So, Ms. Coleman, I'm assuming that we are correct that we can proceed. And then we can, if we need to catch Commissioner Washington up, we can catch her up if and when she gets on. Will that work for you, Cal?
We can proceed with this item, Chair. But the next item, we will need her present.
Right. Because of the waiver.
Correct.
Okay, well, let's proceed with this item in any case. And Ms. Jones, if she needs to call in, she can call in too. But you keep working on it. Let's turn back to Mr. Tedesco. We're still on item 6 on our agenda. And we have heard from staff, and now we will hear again from the applicant just to make sure that it is on the record. Mr. Tedesco, the floor is yours.
Thank you, Mr. Chairman. Again, for the record, Matthew Tedesco with the law firm of McNamee Hosey, here on behalf of the applicant, Marketing Property Company, LLC. With me is also Dominique Lockhart. Our civil engineering team from Bowler Engineering, represented here today by Mr. Nicholas Speech. Our architects are BWD Architects, represented by Ms. Rebecca Brown, and Michael Lenhart from Lenhart Traffic Consulting round out our development team for this application. As mentioned previously, but to be reiterated, there are some minor modifications that Mr. Cofield had referenced in Applicant's Exhibit 1. Those, Mr. Chairman, members of the board, are really just technical clarifications related to ensuring that your resolution, hopefully for approval and at the time of adoption, will provide the correct information referenced from the detailed site plan. So they're more or less just clerical modifications to certain findings and recommended conditions. We did work with Mr. Cofield as well as the urban design team, Ms. Connor, and the department to vet those and the department, as well as the Development Review Division, are all in agreement with those minor modifications. As Mr. Cofield indicated, this proposed detailed site plan contemplates a third consolidated storage building. There are 2 existing buildings on the subject property, lots 3 and 4. Our client, the applicant, is the manager operator of the existing 2 buildings under different entity company names. However, they are the manager operator of the existing facilities. This is simply a continuation to round out the development for this property, which was previously in the I-1 zone, for which this use is a permitted use subject to the approval of a detailed site plan. The architectural elevations as provided in your materials are consistent with the existing development, include high quality design as well as building materials to provide the continuation. There are environmental features on the property that we work very closely with your environmental planning staff. I want to thank them for their review. To preserve the primary management area, the building locations have been somewhat located towards Southern Avenue on the west side of the property. That does allow us the ability to continue to preserve to the maximum extent practical the primary management area, as well as on-site woodland conservation requirements. So with that, Mr. Chairman, as I mentioned previously, this site was entitled about 10 years ago, starting in 2013, 2014, for the development of the property as it is currently developed, but also as proposed here today with this third consolidated storage building on the property in the I-1 zone. With that, Mr. Chairman, as referenced before, with the exception of revisions to applicant's Exhibit 1, we are in agreement with staff's recommendation and its findings and recommended conditions, saving, of course, the amendments in applicant's Exhibit 1, and we would respectfully request the Planning Board's approval of this detailed site plan as modified by applicant's Exhibit 1, and happy to answer any questions.
Thank you, Mr. Tedesco. Commissioners, any questions for the applicant on this item?
Just to be clear, Mr. Chair, so the applicant's Exhibit number 1 makes recommendations, or rather makes amendments to the findings as well as the condition, right?
Correct.
Okay.
All right. Other questions? If there's no other questions for the applicant, no other questions for staff, we have no one signed up to speak on this, I will close this public hearing. And if there's no deliberation, commissioners, what's your pleasure on this item?
Mr. Chairman, I move that we adopt the findings of staff and the findings as amended by applicant Exhibit number 1 and approve DSP-13008-02 and TCP2-018-13-02, subject to the conditions as outlined in staff's report and as further amended by applicant Exhibit number 1.
Second.
A motion by Commissioner Washington, a second by Vice Chair Bailey. Is there any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Giraldo.
Vote aye.
I vote aye as well. The ayes have it 4-0. Thank you, Mr. Cofield, and thank you, Mr. Tedesco, as well.
Thank you all. Have a great day.
You too. Well. We're going to move on to item 8 on our agenda, which is a likely companion to item 9. Item 8 is a waiver of the rules of procedure 4-10020, the Vineyards 2. Again, this item needs to be heard before item 9, which is a request for reconsideration. Mr. Haller has represented the applicant. Mr. Bartlett will give the staff presentation on this item. If action is taken, we need 4 commissioners. That's correct, Ms. Coleman? Okay. Let's turn to staff first. Mr. Bartlett, good morning.
Good morning, Mr. Chair and members of the board. For the record, I am Jason Bartlett with the subdivision section. Item number 8 on the agenda is a request for a waiver of the planning board rules of procedure. And item number 9 is a reconsideration request for preliminary plan of subdivision 4-10020 titled The Vineyards 2. This preliminary plan was approved by the planning board and adopted by resolution on December 4th, 2012. Staff note that no citizens have signed up to speak on these items, and no additional information was received prior to the noon deadline on January 14th. By letter dated December 12, 2024, Mr. Tom Haller, representing the applicant, requested the waiver of rules of procedure first, and if granted, a reconsideration of condition 15F of the preliminary plan resolution on the basis of inadvertent error and furtherance of public interest. The Planning Board previously approved a reconsideration of this preliminary plan in 2019 to adjust the timing for the construction of a master plan trail provided in condition 15 of the resolution. The applicant is seeking a second reconsideration to further revise condition 15 as outlined in applicant's letter to allow the applicant additional time to complete the trail construction. If the request for a waiver of rules of procedure and the reconsideration request for the preliminary plan are granted, staff will provide further analysis on the merits of the request at a later planning board hearing. This concludes staff's presentation. Thank you.
Thank you, Mr. Bartlett. Commissioners, any questions for staff? Seeing none, Mr. Haller, turn to you. Anything you want to add?
Absolutely. Good morning, Mr. Chairman, members of the board. Thomas Haller on behalf of the applicant, U.S. Home LLC. I have with me this morning Mr. Max Potember with U.S. Homes, as well as Morgan with the tech group, who is our engineer. Just one point of clarification. Is the board hearing both items 8 and 9 concurrently, or was this just item 8?
This is just item 8, and then assuming that we take action on item 8, then we'll hear item 9.
Thank you. So item 8 relates to a request for a waiver of the rules of procedure. The board's rules of procedure require that requests for reconsideration typically be filed within 14 days of the action of the planning board. As staff noted, the original planning board hearing occurred in 2012. And as we have outlined in our letter, this was somewhat of an unusual situation because at the time the preliminary plan was initially proposed, there were two components to the preliminary plan, one being a section of single-family detached homes that were proposed to be developed in a portion of the property that was zoned R80. And then there was an additional 124 dwelling units proposed on a portion of the property in the RT zone that would consist of townhouses. 2 weeks prior to the planning board hearing in 2012, the sectional map amendment that had been adopted in 2009 was voided by the court. And as a result of that, although the application went forward, the portion of the property that had been previously zoned RT was placed in an outlot. So all parties knew that at some point in time that property would need to be redesigned in accordance with the new zoning category. And so the issues that have arisen, which have impeded the ability to move forward with that, could not have been known within 14 days of the planning board hearing. I would also note that in 2019, when this matter was before the board previously, the board did find sufficient cause to waive the rules of procedure to hear the reconsideration based upon the facts, which are essentially the same in this instance. So based upon that, we would request that the board waive its rules of procedure and allow for the request for reconsideration to be heard this morning.
Thank you, Mr. Haller. Commissioners, any questions for staff or the applicant on the request for the waiver? If not, I would look for a motion.
Move approval of the waiver procedure, Mr. Chairman.
Second.
A motion by Commissioner Washington, a second by Vice Chair Bailey. If there's no discussion on the motion, I'll call the roll. Commissioner Washington.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Giraldo.
Vote aye.
I vote aye as well. The ayes have it 4-0. Okay, now we are on to item 9. This is the request for reconsideration hearing for the preliminary plan of subdivision 4-10020, the Vineyards 2. We have the waiver. Mr. Bartlett, we'll turn back to you on the request for reconsideration.
Staff has nothing further to add, Mr. Chairman.
Okay, thank you, Mr. Bartlett. Mr. Haller, turn to you.
Thank you, Mr. Chairman. And I would request that Mr. Bartlett's presentation related to item 8 be incorporated into this item as well, just so that that's clearly in the record. And thank you again. I just gave you a brief history of what occurred, I guess, prior to 2019. But with regard to the voiding of the map amendment, so after the property was originally approved in 2012, the single-family detached portion of the property was platted. The land, there was essentially 3 components to the original subdivision. There was the area of the property that was to be developed with single-family detached homes in the original subdivision. There was the area that had originally been approved for proposed for townhouse development. And then there was a third area, which was land to be dedicated to the Maryland National Capital Park and Planning Commission for the construction of a trail. All of those components proceeded forward with the platting of the subdivision, with the exception of obviously the townhouse portion of the property. And 24 acres of the land was conveyed to the Maryland National Capital Park and Planning Commission to accommodate the construction of the trail. The development of the single-family detached portion proceeded as efforts were then commenced to try to redesign the project for single-family detached homes and proceed forward with that. When they got to 2019, the biggest issue that they were trying to address was the delineation of the wetlands that existed on the property. And by 2019, the wetland delineation had been finally resolved. A subdivision number to proceed with the re-subdivision of the outlot that had previously been proposed as townhouses had been assigned. Bond had been posted for construction of the trail, and an NRI was in process, which ultimately got approved in early 2020. Condition 15 of the original subdivision provided for timing for the construction of the trail. And it required that the trail be constructed prior to the issuance of the 60th building permit. U.S. Homes was approaching that point back in 2019, and it was obvious that given the fact that they had not yet been able to file the subdivision, they were not going to be able to achieve that. And so through meetings with the Department of Parks and Recreation in 2019, a request for reconsideration was made to adjust the timing and the triggers for the trail, which involved an amendment to Condition 15. So what the board considered in 2019 was to push the deadline for completion of the trail to the issuance of the last permit of the original section, the 64th permit, and then also to provide additional time for the trail to be constructed. So a new recreational facilities agreement was required to be executed to give the applicant 5 years to either construct the trail or to obtain approval of a new subdivision. And that recreational facilities agreement was recorded in February of 2020. Of course, in 2019, all of the parties involved assumed that 5 years would be sufficient time to engineer the site and to move forward. Because as I just mentioned, the wetlands had been delineated, a subdivision number had been assigned, the NRI was almost approved, bond had been posted. And so when the language was drafted for Condition 15F, a contingency was not included to give the Department of Parks and Recreation the discretion to extend the time frame if there was a reason to do so. Basically, the way Condition 15F was written, either U.S. Home had to complete the construction of the trail, or the Department of Parks and Recreation had to call the bond to do it themselves. And so, as I've mentioned in my letter, while U.S. Homes has continued to diligently pursue the development of out parcel A, where the previous townhouses were proposed, several things have occurred which is beyond the control of U.S. Homes, or quite frankly, the Department of Parks and Recreation, that have prevented the project from being approved. The first initial one was about 2 weeks after the recreational facilities agreement was recorded. The revised agreement was recorded. COVID started, which caused the project to be put on hold for a period of time. And then after when the project began to come back, the wetland delineation that had been approved in 2019 changed in 2020. The regulations dealing with wetland delineations changed in 2020, then they changed again in 2021, and then they changed again in 2022. In 2022. And so the applicant just finally obtained a new updated delineation of the wetlands in the fall of 2024. So now they are required to revise their NRI, and the NRI that was approved in 2020 will expire in February of 2025. And so they're in the process of revising the NRI to reflect not only the change in the wetland delineation, but the Department of Permitting, Inspections, and Enforcement also changed their regulations related to floodplain delineation. So the engineers, Ms. Morgan is on the phone and can give you more details, but our engineers are meeting with DPI to complete a floodplain delineation in order to have that included on the NRI. And as part of that, we'll also need a floodplain waiver in order to be able to have the preliminary plan of subdivision accepted. And then finally, if that wasn't enough, the original plan had been that we were going to file this preliminary plan under the old regulations because everything else had been approved under the old regulations. But that preliminary plan would have to be accepted prior to April 1st of this year. And it is becoming apparent that we are not going to be able to meet that deadline either. And so we'll need to evaluate the filing of the application of the new subdivision and zoning ordinances. And while we don't necessarily think that's going to result in any major changes, we still need to go through that process, apply for a new number, have a new pre-application meeting and a new neighborhood meeting. So you can see that there are a number of issues that have prevented us from being able to move forward, all of which are out of our control. We reached out to the Department of Parks and Recreation last fall, and we asked them, what do you want us to do? I mean, we can give you the money that's in the bond and just be done, or we can continue to pursue this, but we need more time to do it, and we need to do a new reconsideration. And the Department of Parks and Recreation indicated that given the options, they would prefer that we request additional reconsideration and continue our efforts to build the trail. And I would just note, I think Mr. Paul's son is still on the line, but I would note that their position is certainly understandable because if I could ask that we show slide 7 of the presentation. If you look at slide 7, you'll see the original 64 lots that were platted on the left side of that image. The property is bisected by a 250-foot wide Pepco right-of-way that you can see that extends there. And then out parcel A is the property that is proposed to be re-subdivided. And parcel D is the parcel that was conveyed to Park and Planning. And there's a light blue dashed line that runs along the western border of the property conveyed to Park and Planning. And that's the trail segment that we're trying to construct. The trail segment right now, even if it were constructed, would not connect to anything. The only way it would connect to anything is if this parcel is developed and a trail connection is constructed within what is now out parcel A. So if we constructed the trail, or if DPR constructed the trail today, it would connect to nothing. It would simply be a trail in the middle of nowhere. And so developing this property would allow it to be connected and be able to be used by residents of this community as well as the surrounding neighborhoods. And then eventually will be extended into Costco Regional Park. So it's an important trail connection, but even if we constructed it today, it wouldn't connect to anything. And then the other thing is that when we submitted the prior recreational facilities agreement amendment, we also bonded the trail. The bond amount has increased $50,000. The cost of construction has increased $50,000 since that original bond was posted. So even if the Department of Parks and Recreation called the bond, they don't have enough money to construct the trail. And then the final part of it is that all of the engineering work that we're doing, creating the wetlands delineation, creating the floodplain delineation, and getting those all approved, both impact the trail as well. That work needs to be done in order to construct the trail, whether we do it or whether the Department of Parks and Recreation does it. So, all things being equal, I think the Department of Parks and Recreation would prefer us to pay for that engineering rather than them picking up the ball. So for those are the reasons why it makes sense to actually reconsider this. And it is our strong belief that given the recognition of the complexities of developing the site, and the unique history of the property that, there are many times in our lives when we say, we've got plenty of time to do something, and we find out that that's not true. And all we're requesting in this is an amendment to the condition to give the Department of Parks and Recreation the discretion to extend the time. And if at any point they've said, no, that's it, we're done, just give us the money, they'll be able to do that. Now, obviously, the exact language of the revision of the condition would be an issue for the board to consider at the hearing on the merits. But that's the reason for the request and the justification for acknowledging that when we did the reconsideration in 2019, we should have provided that contingency in there in the first place. It was purely inadvertent, but it was an error because it puts us in a position where DPR is essentially forced to call a bond that's not sufficient to construct the trail. So that would conclude my presentation. As I said, I have a representative of the owner and the engineering team on the line to answer any questions that you have, but I do want to assure you that U.S. Homes is continuing to pursue the development of this property. They've been diligently doing so. The portion that is out parcel A will be known as Vineyards 3. The portion that is already developed or substantially developed is Vineyards 2. And there was another section that was Vineyards 1 that started back in the 2003 timeframe. So U.S. Homes has been involved with this property for the better part of 20 years and is committed to completing the development and constructing the trail. So again, I'd be happy to answer any questions, but that would conclude my presentation.
Thank you, Mr. Howell. That was very helpful. A lot of moving parts, but it's clear what we're up against. I'm glad you have staffs in alignment, and we have our Department of Parks and Recreation that feels like it's in their interest that you proceed in the way that you're proceeding. Commissioners, any questions for staff or the applicant?
I just have one question. Mr. Haller, do you have any idea when it would be completed?
If we can, I can't give you an exact date, but what I would tell you, and I think where we are now, I think we're very close to being where we thought we were in 2019. We've now achieved the delineation of the wetlands. We are close to resolving the issues with regard to the floodplain delineation and the waivers that we need from DPI in order to proceed forward to construct the roadway access to serve these lots requires us to impact floodplain. And I think that the trail as well does. And so once we identify specifically what the floodplain delineation is and what those impacts are, and DPI supports that, we'll be able to get the floodplain waiver that we need. And then we can file the subdivision. I would hope that the subdivision can be filed by summer of this year, be completed by fall, and then they can proceed to platting and construction next year. Again, in order to get access to where the trail is, they have to go through this property. And so it will probably take a couple of years to construct it, but I would say we're probably looking at a 2 to 3 year time frame before it can be constructed.
Okay, thank you.
Thank you,
I have no further questions.
Any other questions from commissioners?
No.
Okay, seeing none, we've heard from staff, we've heard from the applicant. Again, there's alignment on this issue. We've known who signed up to speak. Commissioners, what's your pleasure on this request?
Mr. Chairman, I move that we approve the reconsideration request for preliminary plan 4-10020 on the basis of inadvertence and other good cause, in addition to furtherance of public interest, for several reasons as stated on the record by the applicant, to include COVID impacts, wetland delineations changing, as well as zoning ordinance impacts, and that the reconsideration be limited to just condition 15F.
Second.
Got a motion by Commissioner Washington and a second by Commissioner Giraldo. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington?
I vote aye.
Commissioner Giraldo?
Vote aye.
Vice Chair Bailey?
But aye.
I vote aye as well. The ayes have it 4-0. Mr. Heller, thank you very much. And Mr. Bartlett, thank you as well.
Thank you very much, Mr. Chairman, and have a great day.
Same to you. All right, Commissioners, we're moving on to what I believe is the last item on our agenda, item 7. Commissioners, anybody need a break? 15-minute break, would it be helpful? Or should we just proceed?
Proceed.
Proceed, okay. All right, so we're on item 7 on the agenda. This is detailed site plan DSP 22001 McDonald's Acre Road. to note this item was continued from the planning board meeting of November 21, 2024. Mr. Gibbs will be representing the applicant. Ms. Gomez Rojas will be giving the staff presentation. We have a number of folks who signed up to speak. This is an evidentiary hearing, so I'll be certain to swear folks in at the appropriate time. I want to remind folks that as this is a continuation, this is a limited scope to 3 issues and only 3 issues. I'm sure there will be lots of thoughts and comments. I'm going to be fairly strict around keeping us focused on what is pertinent to today's hearing. This has been going on for a while. So again, vehicular and pedestrian circulation in the shopping center is one of the reasons why we continue this. Preserving the buffer area near the historic property. And the third one was incorporating elements of the historic nature of the area. Those were 3 things that we were limiting this continued hearing to. We'll hear from staff. There may be questions for staff. Questions for staff can be from board, from us, from the applicant, or from opposition. Again, questions are relevant to the subject matter of the presentation.
Mr. Chairman.
Yes.
Yes, my apologies. Edward Gibbs on behalf of the applicant. I have a question relative to a point of order.
Sir.
Yesterday, I listened to the entire video presentation from the last hearing, which was November 21st. At the conclusion of that hearing, as Chair Shapiro, you indicated that, first of all the planning board members articulated their concerns, and they were synthesized to be exactly what you just mentioned. At the conclusion of the hearing, you indicated that when we come back on January 16th, we will have a presentation from the staff addressing these issues. Cross-examination of the staff would be allowed. We would then proceed to summarization comments by opposition and then summarization comments by the applicant. Am I hearing now that that's going to change and that full testimony is going to be allowed?
No, let me play through how I expect this is going to be run, and then you tell me, Mr. Gibbs, if there's something that feels like it didn't jive with it, and Ms. Coleman, you can weigh in on that too. So the plan is there'll be the staff presentation on the limited scope. There may be questions for staff, as there often is, questions from the board, but allow for questions from the applicant or opposition. Again, limited to the subject matter of the briefer presentation.
Yeah.
And then, Mr. Gibbs, then you'll have the opportunity for your testimony presentation limited to these 3 issues. There may be questions for you or cross. And then we'll hear from the opposition on these issues. That's the process that we've laid out. Then there'll be an opportunity for rebuttal and summation, and you'll have the last word.
Okay.
Does that meet your?
That's not what was said at the conclusion of the hearing. What was very clearly articulated was cross-examination of staff would be allowed, and then summation and nothing more. So now we're taking testimony, which impacts preparation. I mean,
let me weigh in on that, Ms. Coleman. I'm trying to make sure I understand the distinction between what Mr. Gibbs is saying and what we're proposing here.
Okay, well, not to speak for Mr. Gibbs, but it seems that he is saying that he was hindered in his preparation because he thought that there was not going to be any additional testimony. While this is not a court that's bound by the same procedural order as strictly as what Mr. Gibbs is requesting, it's designed to allow the community to be a participant in the process. And the board's rule of procedure state that an objection to testimony should only be sustained for the most compelling reasons in order to provide a wide latitude to a witness. And this suggests that the board's position is one which stresses the importance that a witness be heard. Matter was continued for the board to receive additional information regarding 3 specific issues. And as such, my recommendation would be that the board receive any relevant information limited to those 3 issues.
Thank you. Mr. Gibbs, I mean, do you feel that this, in terms of your preparation, do you feel that this puts you in a position where you would prefer that we continue this?
I don't want a continuance anymore, Mr. Chairman. I just want to complete this case. And believe me, it hasn't been my effort to prohibit testimony. Obviously, we've had almost 10 hours of this case on the previous dates. So we quite frankly are at one with the staff report. But given that there will be some testimony, I will certainly call my traffic expert and my civil engineer who prepared the revisions to the plans to just make some summary comments. But so I'm prepared to go forward. I would also interpose an objection to the 50 pages of material submitted by Mr. Smith. None of it addresses the 3 issues that we continued the case for and that staff has come back with. It consists of more material on climate change, more material on allegations relative to unhealthy food options at fast foods, impacts of drive-through lanes.
Mr. Gibbs, I'm going to cut you off there. You can save that for your when you're bringing your testimony, and that's for us to determine what is or isn't relevant. I mean, I hear you loud and clear. I'm not disagreeing with you. I'm just saying now's not the time for it.
Okay, great. Thank you very much. Appreciate it.
Thank you. All right, so folks, we're going to go as described in the presentation. Again, this is a limited scope. I'm going to reiterate what this is: the vehicular and pedestrian circulation in the shopping center. Preserving the buffer area near the historic property and incorporating elements of the historic nature of the area. Those are the 3 pieces that are before us, and I will be stricter, but strict to make sure that that's what we focus our testimony on. And colleagues, I would ask you to be mindful of that too, and I'll do the same, work to not bring up questions that stray too far from that, because that won't help the process. So with that, we'll start with staff.
Good morning. I'm doing a quick sound check.
Yes, Ms. Gomez, we can hear you.
Okay. Good morning, Mr. Chair and members of the Planning Board. For the record, I am Natalia Gomez presenting item 7, DSP 22-001. Titled McDonald's Acre Road, which proposes the development of an eating and drinking establishment with drive-through service in an integrated shopping center. This case is continued from November 21, 2024 for a limited scope analysis, as the chair mentioned, in 3 specific areas, which are further outlined in a second addendum to the staff report. And they include vehicular and pedestrian circulation in the shopping center, preservation of the buffer yard adjacent to the historic site, and markers or other historic elements on the subject site. Next slide, please. The first item reviewed by staff is pedestrian circulation. This slide shows the estimated pedestrian circulation throughout the shopping center and the proposed eating and drinking establishment, in which pedestrians may navigate through drive aisles, sidewalks, or crosswalks. Next slide, please. To reduce the speed of entering vehicles and protect pedestrians from exiting on-site traffic, high visibility traffic calming elements are proposed within the site. As shown in this slide, additional pavement markings, crosswalks highlighted in red and speed bumps highlighted in green were added near the driveway entrances and along the drive aisle to the south of the proposed building. To improve access and connections to the shopping center, including the proposed standalone pad-side building, additional strip crosswalks are planned at several key locations. They are shown in blue dotted lines here in the slide. The applicant also proposed 1 additional mid-block crossing on Van Buren Street directly into the parking lot However, DPI does not support the proposed mid-block crossing, citing safety concerns. Instead, DPI recommends installing a high visibility crosswalk at the intersection of Van Buren and Ager Road, where the intersection is controlled by a stop sign. Staff agrees with DPI's determination. Next slide, please. Next slide. Thank you. This slide shows an analysis of the vehicular circulation and potential navigation conflicts within the site, particularly in the entrances closer to the proposed drive-through. In addition to the pavement marking and speed bumps, and to enhance safety and navigation for drivers, additional traffic signage has been proposed to alert vehicles about pedestrian circulation patterns and vehicular patterns and one-way traffic throughout the parking and drive-through area. This traffic signage includes signs for stop, do not enter, right turn only, and not pedestrian access. They are all reflected in the slide shown here. Next slide, please. The queuing analysis submitted by the applicant for the drive-through lane portion of the proposed development allows for approximately 12 to 14 vehicles in the double drive-through lanes, from the order lane to the drive-through entrance. An additional space is available to accommodate 6 more vehicles between the pickup window and the order board. This slide here shows that according to Section 27-274C6 of the prior zoning ordinance, the design of the drive-through does not conflict with the circulation patterns or pedestrian access shown before. Next slide, please. On December 20, 2024, the Planning Department, the applicant, and the State Highway Administration held a meeting to discuss the proposed plans on the right-way of MD 410 or Eastway Highway and any potential impact to the proposed DSP. During the meeting, it was determined that the modifications proposed by the SHA would not have any impact on the landscaping plans outlined in the current application. As shown in these concept plans provided by the State Highway Administration, which I want to emphasize that they are only currently on design phase, these are not definitive plans. They show a portion of the frontage of the site that will be impacted by the sidewalk widening along Eastway Highway. The construction of an ADA ramp is also included in a crosswalk at the intersection of Van Buren Street and Eastway Highway. The State Highway Administration also confirmed during the meeting that they have no additional comments on the subject application, nor are requesting the elimination of any existing driveway access. And lastly, they are in support of an additional pedestrian sidewalk connection to the eastern portion of the site. Staff from the Transportation Planning section is also available to answer any questions related to the SHA associated plans shown here or any vehicular pedestrian circulation questions. Next slide, please. The applicant withdrew the request for departure from design standards DDS-23001. Therefore, the DSP must conform to section 4.7 of the 2010 landscape manual, which requires a type D buffer yard along the eastern property line adjacent to the historic site. The applicant submitted a revised landscape plan, which is in compliance with the required buffer yard using existing and proposed plantings, pursuant to section 4.7 of the landscape manual. However, to comply with crime prevention through environmental design principles regarding surveillance and minimizing blind spots that could facilitate illegal activities, staff recommend trimming any low-hanging branches of existing trees to create a minimum clearance height of 8 feet. As previously stated, the feasibility of trimming trees will depend on their health and species. Next slide, please. In response to the Planning Board's request to highlight the historic features of the area, the applicant has committed to design and install posters in English and Spanish within the eating and drinking establishment. These posters will highlight the unique historical features and significance of the area, providing patrons with a deeper appreciation of the local's rich heritage. All the findings presented here, in additional recommended conditions, are listed in the second addendum to the staff report. The second addendum also notes those conditions which are no longer relevant from the original staff report in the first addendum due to the plan revision that has been made. As a matter of housekeeping, staff would like to correct the tiny typo on page 5 of the second addendum. Staff recommend updating the last line in page 5 as I will read into the record. After reviewing the revised plans and additional information submitted by the applicant, staff determined that the following conditions listed in the staff report are no longer applicable. 1C, 2A, 2C, and 3B.
3B.
Yes, not 3C, 3B. Staff recommends the planning board adopt the findings listed in the staff report and the first addendum as further modified by the second addendum to the technical staff report and approve DSP-22001 and TCP2-004-2024 with the conditions found in the staff report and the first addendum and as further modified by the second addendum. This concludes the staff presentation. Thank you.
Thank you, Ms. Gomez. I'll turn to first the board to see if you have any questions for staff on the presentation that you just heard.
Yeah, just a clarifying question for staff. Could you please restate the conditions you said that are no longer applicable, I believe, in the first agreement?
Yes, the conditions that are no longer applicable from the staff report are conditions 1C, 2A, 2C, 3A, and 3B.
B, that was the change from C to, got it. Thank you, Ms. Gomez. That's it, Mr. Chairman. You're muted, Mr. Chairman.
Thank you. Commissioners, any other questions for staff at this point? No other questions. We'll turn to the applicant. Do you have any questions for staff at this point?
No, I do not. We are in support of the second addendum to the staff report and all of the conditions, including the revision to include 3B and not 3C. I don't think there is a 3C. Thank you.
Okay, thank you. And then we'll turn to the opposition. I see Mr. Smith. There may be other folks as well. Ms. Coleman, help me with this. If Mr. Smith is crossing, has questions for staff, do I need to swear him in at this point?
For convenience, yes, I would swear him in, even though it's a cross, and probably his oath is still good from the last hearing. But just so everyone's clear, you might want to just get that out the way now.
Mr. Smith, if you raise your right hand, sir.
Are you asking me to swear? Is that what's going on?
Can we swear at each other for a few minutes? Is that all right?
Yeah, let's go. All right. Yeah.
If you could raise your right hand, do you solemnly swear or affirm that this testimony will be the whole truth and nothing but the truth?
I do. It's just cross, not testimony, but yes.
Okay. So if you have a cross for staff on the presentation that you just heard.
Yeah, just a couple of questions. One, I just want to understand how the pedestrian access analysis is done. Did it rely on just 20 cars total queuing, the 14 in the order line and the 6 in the window pickup line? And my question is, did it stop at 20, or what happens if more than 20 cars are queued at this site? How does that affect on-site circulation of cars and of pedestrians or bicyclists?
Gomez, are you prepared to answer that, or is there a transportation staff that might be able to chime in?
Yes, I will defer the question to Ben from transportation section.
Mr. Patrick.
Good morning. Just doing a sound check.
We can hear you fine.
Great. I'm sorry. Could have the question repeated, please?
Mr. Smith, if you could repeat for Mr. Patrick.
Yeah, I just wanted to make sure I understand how the on-site circulation analysis was done. Ms. Gomez-Ross mentioned that it looked like there was capacity for 14 cars in the 2 order window lines, and then 6 cars to the pickup window line. It looks like it topped out at 20. Was there any analysis done or consideration given to if there are more than 20 cars queued and extends a bit deeper into the parking lot, how does that affect vehicular circulation and bike ped circulation on the site? As well as how would it affect cars coming off of Ager onto the site? Could it cause some conflicts there if there's a longer queue?
So in regards to pedestrian circulation, I think the largest part of the analysis we included this time was the circulation plan that came out there. That you're describing, we have shown from the order window, thank you, we've shown queuing in the drive-through, both lanes of the drive-through, and sort of the receiving that comes around by the dumpsters that comes up there. What you're speaking to is that there are the capacity for 20 vehicles in total from that order window back to be stored. And I guess to finalize your question, had there been additional queuing that would back up further into the areas, we did not show that graphically in the exhibit, no.
Oh, you didn't show it. Was there any analysis or thought given to what happens if there is a longer queue? I mean, this.
If the answer is
I want to
no,
get into testifying, but it sounds like. Are you taking that as a no? Okay.
Yeah, I mean, I want to speak for Mr. Patrick, but I'm hearing no. But
Okay.
you know, yes or no? Did you look at what it would be like if there was more than the 20?
No.
Okay. All right, Mr. Smith. Other questions?
Yeah. So there's a somewhat significant change to the landscape plan, and we welcome the fact that fewer trees will be destroyed on the site. How does that affect the total area of impervious surface, and how might it I'm assuming there's an interplay between the landscape plan and the stormwater management plan. Is it possible that the applicant should come back with a revised stormwater management plan now that they've changed their landscaping plan so significantly?
Gomez, would that be you or environmental or and again, focused on what your presentation was related to this, but do you have an answer for Mr. Smith?
Right. So the stormwater plan is not part of this scope hearing. We already submitted enough information regarding that item, but according to the landscape plan, there are the reduction of trees are going to be minimal, almost nothing. What we are requesting, we are not just to clarify, we're not requesting any cutting trees. We are requesting to trimming any low-hanging branches. That we are not requesting the cutting of trees. In fact, the buffer that is now that they need to comply with now, that subject to section 4.7, they will be using existing and proposed plantings. It's a mixture of both. Hope that answered your question.
Thank you, Ms. Gomez. Mr. Smith.
Not really, but yeah, I'm assuming that there's some sort of interplay between the landscaping plan and the stormwater management plan. And my question was, now that the landscaping plan is being changed significantly, and again, we welcome less tree destruction, might that necessitate a revised stormwater management plan?
Ms. Gomez said that's not part of this.
Yeah, she said it's not part of the scope of the continuance, but it's kind of a different question. But thank you.
Other questions you have, sir?
I understood it differently. I understood it that there's no trees that are going to be displaced; they're going to only be trimmed. So I don't know what the relationship would be between that and the stormwater management, Mr. Smith. That's what.
Well, I'm not going to get into testimony.
No, that's what Ms. Gomez said.
As an interested party who thinks about these things a little bit, I was saying, well, it seems like these two things interact. We take the site holistically. If one thing changes, should the other thing change? So that's all.
All right. Thank you.
Thank you.
No other questions. Anyone else in opposition have questions for staff? All right, then we will move to the applicant and Mr. Gibbs. You again, this is limited to the 3 issues of the hearing, and the floor is yours. You're on mute, sir.
I am going to ask for some comments briefly by Mr. Nick Speech and Mr. Michael Lenhart. Mr. Speech will go first.
All right, and Mr. Gibbs, I'm going to remind you, just like I am everybody, the folks who you're asking to speak are going to be speaking just to these items that are part of the limited scope hearing, correct?
You may rest assured it will
All right,
be
thank you.
restricted.
And I'm going to swear in folks as well, even if you've already been sworn in before. So who do we have? We have Mr. Speech and who?
Mr. Lenhart.
Mr. Lenhart. Mr. Lenhart, can you pop on too? Save me some words. If
I'm
both
here.
of you could raise your right hands. Do you solemnly swear or affirm that the testimony that you present will be the whole truth and nothing but the truth? Okay, consider you're both under oath. We'll start with Mr. Speech. I believe that's what you said, Mr. Gibbs, correct?
Yes. That's correct. Thank you very much. Mr. Speech, you are in fact the applicant's civil engineer with Bowler Engineering in this case, correct?
That is correct.
And you have testified previously in these proceedings, correct?
That is correct.
And you have been present for all of the proceedings which have gone before us, leading us to today?
All of them except for one. One of my colleagues filled in for me at the last hearing as I was out of town.
Okay, thank you. Now, subsequent to the last hearing, did you and your firm prepare revised drawings which, number one, incorporated the site plan changes recommended by staff in their first addendum, which was considered at the November 21st hearing, and number two, add additional vehicular and pedestrian safety elements?
We did, yes.
And did you and your firm consult with staff at the Park and Planning Commission in the preparation of these revisions?
We did multiple times.
And the document that has been presented by staff today on the screen, from which Ms. Gomez Rojas made her presentation, in your opinion, does that accurately reflect the changes which you made?
It does. I think staff did a great job presenting it, and I don't think they left anything out.
And within your realm of expertise as a civil engineer, looking at those changes, do you have an opinion as to whether or not they further enhance both vehicular and pedestrian safety on site?
I do. I believe that with more pronounced crosswalks, sidewalks, safety features such as stop bars, painting on the surfaces, speed bumps, it definitely will enhance the safety, pedestrian and vehicular.
And at the last hearing, this is relative to controlling pedestrian activity on site. The chairman made a comment relative to the condition of fencing. Did your revisions to the plan actually include the addition of another fence in order to further control any access into the center from the loading zone?
Sure. Additional fencing is shown on the plan, yes, as well as signage to limit pedestrian, access to the loading area behind the building. I also would add that there were some parking spaces that were behind the building. And so in order to keep folks that are parking in those spaces from traversing the majority of the site behind the buildings, an additional crosswalk was added back there as well to direct pedestrians directly to the McDonald's, further enhancing safety.
Okay, thank you very much. No further questions.
Thank you, Mr. Speech. Ms. Coleman, if there's cross at this point, or do we hear from Mr. Lenhart? What's going to make the most sense?
At this point, Chair.
Okay. All right. So, commissioners, any questions for Mr. Speech?
I have one question, Mr. Chair. I'm looking at the circulation for the drive-through, and is there going to be any signage for when the vehicles on the outer lane have to cross over into the other lane to get to do the pickup? Am I making sense?
I understand what you're saying. Absolutely. There's striping on the drive-through lanes themselves to direct traffic. So yes, there will be some additional measures so that folks will know how to merge.
Yeah, because I'm just thinking in terms of the way people sometimes do the roundabouts in the county, and they kind of like everybody tries to be first. That's what. And I was wondering if there would be some sign that said, every other car, or one car goes and then one from the other lane car goes. You know what I mean?
Sure, and I think, like I said, the striping on the pavement certainly will help that. I think also, and it gets into operations, but the way orders are taken, not done at the same time, which allows the cars to differentiate which one pulls forward next.
Okay, thank you.
Thank you. Commissioners, any other questions for Mr. Speech, Mr. Gibbs at this point? Not, I'll turn to the opposition, Mr. Smith, or others, parties in opposition. Though Mr. Smith, I know you've been taking the lead on this. Mr. Smith, questions for Mr. Speech or Mr. Gibbs? You're on mute.
Or, yeah, sorry about that. Yeah, essentially the same question I asked staff. Looks like the analysis topped out at 20 cars in the queue between the two different segments of the queuing. Did your firm take a look at what happens if the queue is longer than that? I mean, I appreciate that an effort has been made here.
Objection. It's beyond the scope of his testimony, but it will be a proper question for Mr. Lenhart in just a second.
Well, let me ask the question a different way, Mr. Gibbs. Thanks for your objection.
Mr. Smith, if he objects, I'm the one who determines whether it's appropriate or not. I actually agree with Mr. Gibbs. I think that this is more of a question for Mr. Lenhart, who's has done all the traffic analysis. So if there's a piece of this that you feel is appropriate to what Mr. Speech testified to, feel free. But I know where you're going because you heard the question before and hit Mr. Lenhart.
I'll just reframe it. I appreciate the effort made here as somebody who doesn't drive very much. I bike and walk most of the places I go. Did your design consideration assume no more than 20 cars in the queue?
Our design consideration, we assumed 20 cars in the queue. That is correct.
Okay, thank you. Thank you, Mr. Smith. Mr. Gibbs, if there's other questions,
maybe a quick follow-up. Just in your professional opinion, if the queue is longer than that, does that somehow undermine the effectiveness of some of these safety features? Could it?
Objection again, same reason.
I think that's going to be a Mr. Lenhart question, Mr. Smith.
I thought that Mr. Speech was the safety expert. That's why I asked him. Thanks.
Understood. All right, Mr. Gibbs, to you.
Yes, Mr. Lenhart, for some brief questions. Mr. Lenhart, are you ready?
Yes, I'm ready when you are.
Okay, great. So, Mr. Lenhart, have you been present during all of the testimony and all of the prior sessions of the planning board in this case?
Yes, I have.
And did you testify at the initial hearing before the planning board in October?
I did.
And did your testimony at that time indicate, in your opinion, that the application was in conformance with relevant provisions of sections 27.281 through 27.285 and including section 27.274 relative to on-site circulation and safety?
Mr. Lenhart, I didn't hear you.
Yes, sorry.
Okay, thank you. Did you also testify as a rebuttal witness in this case at the November 21, 2024 hearing?
Yes, I did.
And during that testimony, did you go into substantial detail relative to the conformance of the site plan, in your professional opinion as an expert in the field of transportation planning, relative to conformance with those provisions of the zoning ordinance? I'm sorry, Mr. Lenhart, you might have to speak up. I'm not sure everyone can hear you.
Yeah. Yes, I did. Sorry.
Okay, thank you. Now, when the case was continued on the November 21st, did you participate in any meetings with staff relative to an effort to provide even further pedestrian and vehicular safety measures for the site?
Yes, we did have a meeting with staff, and I was involved in that.
Okay. And in your opinion, have the changes which have been presented today been in conformance with the recommendations that you made as well?
Yes.
Now, there was also a request to provide a stacking analysis, and did you prepare a memorandum which was submitted into the record analyzing stacking at the drive-through lane?
We did prepare the exhibit that was associated with the PowerPoint presentation that showed the queuing and stacking. And yes, we did include that.
Okay. Now, is a stacking or queuing analysis actually required by the prior zoning ordinance under which this case is being considered?
It is not.
But you went ahead and did that as a matter of extra caution, is that correct?
We did. So the prior ordinance 27-274 E6 specifically requires that drive-through establishments should be designed with adequate space for queuing lanes that do not conflict with circulation traffic patterns or pedestrian access. There is no requirement for any specific amount of queue, and it's been typically left up to interpretation or information elsewhere that could be used to support the amount of queuing that's provided.
Does the new ordinance have a queuing requirement?
It does.
Okay. And could you explain to the board whether or not your analysis and this drive-through lane satisfies even the new zoning ordinance requirements for queuing?
It does. The new zoning ordinance requires that there should be enough queuing for 6 vehicles to be stacked back from the order board, not the pickup board. So it's not the total amount of queuing, it's the amount of queuing that's available from the order board. Our study shows that the queuing exhibit, if you go to the staff report, I think it's page 4 of the staff report.
Slide 4?
Page 4.
Oh, page 4 of the report itself. Okay.
Report, or in the PowerPoint, it's slide 5.
Okay. All right.
And
yeah.
So you can see the pickup window on the side of the building allows for, from the pickup window, 3, 4, 5, 6 vehicles can be queued between the pickup window and the order boards. The order boards are the 2 side-by-side vehicles that are where the median is in the dual drive-through lane. And so from the order board, you can count 2, 4, 6, 8, 10, 12, 14 vehicles there that stack from the order board back before traffic would be queued back into the circulation area of the of the parking lot. That is more than twice the amount of vehicles that are required by the new zoning ordinance. I can also say that there are queuing studies that have been done and published through the Institute of Transportation Engineers for different types of drive-through facilities. One study for fast food queue lengths is broken down into different fast food types, and with hamburger joints, the maximum queue observed was 13. Well, there were 27 studies. The maximum queue observed throughout those 27 sites ranged between 4 and 13 vehicles queued in the entire queue. And so we're showing a total of 20 in the entire queue. By all accounts, by all data, by everything in the zoning ordinance, this far exceeds the requirement. And we have no information or evidence that would ever exceed this amount, to Mr. Smith's question.
Thank you very much. Now, Mr. Lenhart, just wrapping up here, two other questions. The revised plan shows a mid-block pedestrian crossing on Van Buren.
Yes.
What?
Can we go to that slide, Mr. Gibbs?
Yeah, there we go. The slide 3.
Thank you, sir.
So, was that crosswalk installed after observing where traffic is actually occurring to cross the street?
Yes. When we met with transportation staff and planning staff at your offices back before the holidays, this was one of the items we discussed. There is the apartments across on the other side of Van Buren. There's a sidewalk that comes down between the apartment complexes, and the sidewalk comes out and intersects Van Buren at about that location, and then it transverses both directions along Van Buren. But it appears that people are crossing Van Buren at that location, and it appears that way by a worn path in the grass on the site side of Van Buren at about that location. And so we had added this as a potential crosswalk based upon that observation and discussion.
And DPI has indicated, if I recall your observations correctly, that the mid-block crosswalk would generally not be approved. Is that correct?
That's correct. They were not in support of the mid-block crosswalk.
Did you participate in the meeting with the State Highway Administration, which staff had?
Yes.
And you heard the recitation of staff this morning relative to the results of that meeting. Does that coincide with your recollections as well?
Yes.
And during that meeting, did the State Highway Administration at any time ask for the closure, relocation, or modification of other driveways other than the two immediately in front of the proposed McDonald's site, which are going to be consolidated as a right-in, right-out?
No, they did not. They raised no objections to any of the other driveways.
And just one final question. I know you've given this opinion at least twice before in this case, but based upon your professional background, your involvement in cases of these nature, and on your expert opinion, do you have an opinion as to whether or not the development of this McDonald's and its impact on the site in general will create a safe situation for both vehicular and pedestrians as well as the bicyclists who may be at the site?
Certainly. It's my opinion that with the improvements that have been requested by State Highway to close one of the two driveways and consolidate into a right-in, right-out, channelized right-in, right-out as shown on this plan, to add the sidewalk tie-ins from the existing sidewalk along Ager Road into the site, along with the crosswalks, that provides safe and adequate pedestrian access. The proposed speed humps that have been added to the plan will slow and control vehicles. The pavement markings to be added within the drive aisle of the site in front of the existing shopping center to add those slow markings also will encourage slower speeds through the center. And so, yes, it's my opinion that with all of these improvements, that it will be safe and adequate for vehicles, peds, and bikes.
Thank you very much. Nothing further, Mr. Chairman.
Mr. Chair, just to clarify the record, Delisa Coleman, Senior Counsel, because we've had so many addendums to the staff report, I just want to confirm that when Mr. Lenhart was discussing the drive-through queuing and he referred to page 4 of the staff report, that he was referring to page 4 of the second addendum to the staff report.
Right.
That is correct, which matches the exhibit slide 5 of the PowerPoint presentation.
Thank you, Ms. Coleman. Ms. Lenhart, Mr. Gibbs, all fine with that?
All fine, Mr. Chairman. We agree.
Okay, thank you. All right, let's turn to first the board to see if there's any questions for Mr. Lenhart and Mr. Gibbs, and then we'll turn to the opposition. Start with my colleagues. Commissioners, any questions?
None.
Okay. We'll turn to the opposition. Mr. Smith, let me just see, is there anyone else besides Mr. Smith who wants to ask questions? I just want to help with the management of the time. All right, Mr. Smith, turn to you.
Yeah, I think unfortunately some of our members of our team have had to leave because of work commitments that they couldn't break again. But just a few quick questions. Mr. Lenhart, you've referred to the ITE queuing analyses a number of times in the hearings. Do you know whether any of those sites that were looked at by ITE to provide this sample are from Prince George's County or the DC area?
I don't know that.
Okay. Do you know whether those observations were taken before COVID, during COVID, or post-COVID?
They were all pre-COVID.
Oh, okay. Thank you. And I know that in relying on those ITE analyses, you said that they found a maximum of 13 cars in any queue. But again, in your opinion, if the queue were to exceed I guess it's 2 lines of 6 or 7 cars each, could that affect traffic coming off of Ager 410? Could it affect on-site circulation of vehicles, and could it affect on-site pedestrian and bicycle access and safety if it backed up farther?
Your question presupposes that it will back up and extend into those areas, and
I don't think it does. Simply ask what would happen if it did.
Let me jump in. I think because I could answer that. If 50 cars backed up, it would be a nightmare. There's nothing else to say, right? I mean, they're saying that that's what they're projecting, but I agree with you, Mr. Smith. If there were a whole lot more cars, it would be a big problem. I mean, how could it not be? They'd be backing up into the roadway.
Well, I could offer you background on why I asked that question, but maybe I should save that for my testimony.
Probably. But I mean, I want to make sure that the question's asked and answered. So, because I jumped in, Mr. Lenhart, do you have an answer to the question?
Well, if there were 50 cars in line, that would interfere with on-site circulation and whatnot. The fact is, none of the queuing data that we have from ITE indicates that it would extend beyond the queuing capacity that we're showing in this plan. This exceeds zoning code requirements, and it exceeds all the queuing data that we have.
Right. Thank you. Mr. Smith, still with you. Any other questions for Mr. Lenhart or Mr. Gibbs at this point based upon their application, their testimony?
No, thank you very much.
Thank you, sir. All right, so we will move on to opposition testimony. Again, limited to the 3 issues of the limited scope hearing. After your testimony, Mr. Smith, or if there's other folks as well, there'll be questions. We allow for questions to you from the board and the applicant, and the floor is yours. Oh, wait,
Happy to clean up. I don't know who else is still here able to testify.
I see Mr. Cronin.
Yes, I would like 90 seconds, Mr. Chairman, to address the vehicular and pedestrian circulation issues, and I'm happy to go before or after Mr. Smith.
All right, thank you, Mr. Cronin. And I see Mr. Boato. Are you going to testify too? Of course, if you'd like to, by all means.
Yes. Can you folks hear me okay?
Yes, sir.
Okay, I'm so sorry about the headphones, but it's the only way I was able to manage to hear you.
You're very stylish. It looks good.
Thank you. I just wanted to make a comment about the historic.
Before you go, Mr. Boato, I just want to. Okay, that's what you want to talk about, historic.
Yeah.
Mr. Cronin and Mr. Smith. Anyone else? Then let me go in this order. Let me do Mr. Cronin, then Mr. Boato, and then Mr. Smith. And take your time, folks. Just keep it focused on what's within the limited scope. But the applicants had a fair bit of time, and we want to make sure the opposition has up to that amount of time as well. So, Mr. Cronin and Mr. Boato, let me swear you both in. We've already sworn in Mr. Smith. If I could ask you both to raise your right hands. Solemnly swear or affirm that the testimony you're about to provide will be the whole truth and nothing but the truth.
Yes, I so swear.
Okay, consider yourself both under oath, and we'll start with you, Mr. Cronin.
Mr. Chairman and members of the board, thank you. I will be brief. For the record, Jeff Cronin from the Carroll Highlands neighborhood in Prince George's County, 7217 15th Avenue. This is one of the most dangerous stretches of roads in the state of Maryland, as I think the record indicates. The State Highway Administration has a context-driven pedestrian safety plan to address some of these issues on East-West Highway. I think the key words there are context-driven. The context has to drive the plan, and I would urge the board to consider this application in the real-world environment where people live, work, commute, and shop, and not in a vacuum. I believe the record indicates that the traffic estimates provided by the applicant are fanciful. In fact, I believe that the high throughput drive-through proposed here increases the likelihood that more pedestrians will suffer injuries or fatalities after colliding with a vehicle. Neither the planning board or the State Highway Administration are going to fix this dangerous 5-point intersection overnight, but today you have a chance to make things better or to make things worse, and I would urge you to make things better here by denying this application, and I thank you for considering my views.
Mr. Cronin, thank you very much. I appreciate it. Questions for Mr. Cronin? I'll take them one at a time. Commissioners, any questions for Mr. Cronin? Mr. Gibbs, any questions for Mr. Cronin? Any cross for Mr. Cronin?
None.
Okay, thank you all. Mr. Boato, turn to you.
Yeah, just a quick comment. I'm so disappointed to think, and I think you should all think carefully about this before you approve, that you're going to venerate a bunch of people who were enslaved and died on this property by putting a bunch of posters in a McDonald's. I think that's crazy. I don't think that meets like a minimum standard of historic preservation or education for the public. And I'm just really disappointed that that was even considered. Thank you.
Thank you, Mr. Boato. Any questions for Mr. Boato, commissioners? Or Mr. Gibbs?
No questions.
Okay, all right, thank you. And now we'll turn to you, Mr. Smith.
Thank you, Mr. Shapiro. I'll explain why I asked where and when, especially when the ITE's queuing analyses were done.
Mr. Smith, my apologies, Mr. Chairman. I'm having huge connection issues. I was trying to jump in with regards to the last individual who testified regarding the memorial markers, if I may.
Yes, of course.
Yeah, I would like to ask Mr. Gibbs, because I too was a bit struck by just having the posters, as they've been referred to commemorate that historic site. And Mr. Gibbs, I wonder if you and or your team considered, at least in my mind when I raised it at the last hearing, I was thinking about something more substantive to include a marker or something on site external to the restaurant. And I just wonder if you all considered that, or would you consider that?
Yes. Yes, Commissioner Washington. Basically, our thought process was to have very tasteful information, which the most people would have an opportunity to see and read, both in English and Spanish. That's why we opted for information internal to the building, again, to be presented artistically and tastefully. We would have no objection to putting some marker on the exterior of the site. Our concern is putting a marker in the rear of the site, giving the vandalism that has been experienced over the course of time, and further, given the fact that any type of pillar or pole is going to do nothing other than create another opportunity for trespassers to tie off tarps to sleep behind the shopping center. But if there's an idea that the board has, first of all, we went out and proactively retained the services of James Gibb, a recognized expert archaeologist who has testified many times before the planning board and the district council in Prince George's County and other counties. He looked at everything out there and he gave us a letter report, which we put into the record. And of course, he is also going to be on site for any work that is done to address the earlier condition recommended, I think, in the first addendum to the staff report. But if there is something further that we can do that would make more sense to you or to the board, please just add it as a condition. We're happy to do it. We just thought that the posters, tastefully presented, tastefully framed, there would be an opportunity when people are actually sitting and enjoying their food to actually read the posters, as opposed to having a marker outside that many people would never have the opportunity to stop and read. But if you feel otherwise, we're 100% open.
No. And I really appreciate you explaining that. But I do believe what you described is very good in terms of having that inside the restaurant. I would just ask that, you all, and it certainly would not be me, but maybe Mr. Chairman, our historic committee could work with the applicant to come up with something tasteful that would not, to your point, Mr. Gibbs, create yet another opportunity for vandalism or something, just something outside, because people walking and passerbys, I know I've encountered historic markers like that personally, just stumbled upon it. And I think that would be very helpful. So I thank you for your willingness to do that.
No, absolutely. And quite frankly, if that's the direction that the board would like to proceed, we could have an additional condition added, which would specify that the applicant's archaeologist work with Historic Preservation Division staff to determine an external historic marker which could be placed within the shopping center.
That would be wonderful. And I am suggesting, in addition to the posters inside, because as you described them, I think that's a wonderful idea, actually.
Right. And that would be in addition to the posters. Yes, we would embrace that condition. Yes.
Wonderful. Thank you, Mr. Gibbs. That's it, Mr. Chairman.
Oh, thank you, Commissioner. I felt the same way. I think that actually the direction that Mr. Gibbs recommends is where I was in my head too, which is that we condition this to have them work with our Department of Parks and Recreation, Historic Preservation Division.
No problems with that, Mr. Chairman.
Great, thank you.
Mr. Buato, for what it's worth, you're heard loud and clear, and I think we have a real opportunity here.
Thank you very much.
Okay. Other questions for Mr. Water, Mr. Cronin? No, so we're back to you, Mr. Smith.
Thank you very much. Just want to put a pin in this issue. The question I was raising about when these ITE queuing analyses are done is relevant because literature out there that shows that reliance on drive-through windows increased sharply during COVID and stayed high. It didn't just drop down to pre-COVID levels. So if the queuing analysis relies solely on pre-COVID queues, may not represent what the volume of cars that would be using a drive-through window at any fast food joint. And to ignore that reality means there's a possibility of understating the traffic at the drive-through window, the queuing, and the impacts on traffic coming off of 410 and circulation and safety on the site. That's why I raised it. This is an auto-dependent, auto-centric restaurant, period. And that's reflected by the fact that they want to build more, they want to have more than 50 parking spaces on the site, capacity to queue up 20 cars. So again, to ignore that reality and then also to ignore the off-site context and the off-site impacts is unwise, and it can lead to ill-informed decisions. I haven't heard any justification for ignoring off-site context and impacts, and I've placed on the record, swinging back to this is, and we are an auto-centric, auto-dependent region because of decades of bad planning, and we can have long conversations about that, but that's the reality. And an out-of-county corporation wants to place a high-volume fast food restaurant at one of the most dangerous intersections that links some of the most dangerous road segments in the county. We're not looking at these transportation realities. So that's why I raised that issue.
Mr. Smith, I hear you, but please focus the opposition, your testimony on the three issues that are before us.
Okay, now swinging back to the landscape design, we're all very happy that fewer trees are going to be destroyed on the site. It's just fewer trees. It's not no trees, because they say it depends on the condition, the health of the species, and the condition as to whether or not they'll be trimmed and how they'll fare if they get trimmed up to 8 feet. But it's great that fewer trees will be destroyed on a site that's in the middle of an intense urban heat island. That said, and I want to get to this point, there's an interplay between what happens on the landscape and how stormwater will flow on the site. And the stormwater, it's not clear, based on the information we've seen so far, how this change in the landscaping will affect stormwater flows on the site. And so it may be wise to ask the applicant to come back with a revised conceptual stormwater management plan so you can understand that. I have placed a ton of information on the record on what's going on.
I object, Mr. Chairman, I object. Stormwater management is not one of the three issues. And it goes back to my objection to the 50 pages of totally irrelevant information that Mr. Smith put into the record that doesn't address any of the three criteria.
Well, I'm fairly certain that Mr. Gibbs would find any information we put in the record irrelevant. But anyway, I'm going to say the reason this is so important is partly because of the evidence that we have placed in the record regarding stormwater and climate change. And I know that we're not going to focus on that today, but I have to ask you today, because it's in the record, you take a thoughtful look at the evidence we have placed in the record on those issues. And I just want to say, I will close by saying, there is nothing that I know of in the law prevents you from looking at off-site context, off-site impact. And in fact, the very fact that the ordinance specifically requires that a DSP be referred to the
Objection.
Mr. Gibbs, I did not interrupt
Mr. Chairman,
you.
Mr. Chairman, this has occurred for over 10 hours.
Mr. Smith, Mr. Gibbs, both. Stop.
I'm just pitting this. I'm going to put it in the record one more time. It is a serious deficiency that no health impact assessment has been done on this project within this context. Thank you very much. And I urge you to deny the DSP. Thank you.
Thank you, sir. Commissioners, are there questions for Mr. Smith? All right, Mr. Gibbs, do you have any questions for Mr. Smith?
None.
Okay, thank you. So now we have before us opportunity for rebuttal. We'll start with the applicant. Well, we'll have rebuttal by the applicant, and then if there's any summation by the opposition, and then summation by the applicant. I would ask all of you, both of you, to please not be repetitive. I think we've heard loud and clear where you're coming from, but this certainly is your time, so I will give you that time. So we'll start with rebuttal by the applicant if there is any.
If you could just give me a moment, Mr. Chair.
I'm fine if we want to take a 5-minute break or something like that, if that's going to help you and perhaps Mr. Smith, if you want to gather your thoughts for a few minutes.
Whatever pleases the board.
That'd be great. Thank you.
Okay. All right, let's take a 5-minute break. We'll it's 9:44. We'll start. I'm sorry, 12:44. We'll do 12:50.
Which one?
Okay, make sure we're all back. I see Mr. Smith, I see Mr. Gibbs, I see my colleagues, I see Ms. Coleman, Waddell. Okay, I think we're good to go. So we have what's left before us is rebuttal by the applicant, and then summation by the opposition and summation by the applicant, and then to us. Commissioners. So we'll start with rebuttal by the applicant. Mr. Gibbs, the floor is yours.
Yes, Mr. Chairman, no rebuttal.
Okay. Summation by opposition. We will turn to you, Mr. Smith, if you have anything under summation. Again, the floor is yours. I would ask you not to be repetitive, but if there's something you feel you want to bring to us in summation, by all means.
Can I say something in summation too? If only just a few
Sure.
sentences.
No, Mr. Boato, absolutely. I'm sorry.
Okay.
Actually, would you like to go first?
Sure. So I wrote down a few things during the break, and I hate to say this, but I feel like the planning board is really failing the community, and I think you've allowed yourselves to be distracted by like the nuances of this DSP rather than considering the big issues. And that's how they always win these things, right? You get caught up in the nuance. So instead of considering health impacts to an EIJ community that doesn't have health insurance, we're going to stick a McDonald's, right? Where we've managed to work traffic out of consideration. We've managed to work pedestrian safety out of consideration. We've managed to send walkability out the door. And in the end, what are we doing? We're voting for a publicly subsidized for-profit business to come into our community. Thank you very much.
Mr. Waddell. Next, we'll have Mr. Smith.
Thank you, Mr. Shapiro. I'm not going to, despite being a veteran of some of these processes, I'm not going to presuppose the board's decision here. I'll just put a few basic points on the record here. First of all, the zoning ordinance looks like, am I still on?
Yes, sir. You're still on. We can hear you.
Something odd happened on my screen.
Are you okay? Can you hear us?
Yeah, I can. There we are. Back. I don't know what. There was some sort of pop-up query. The zoning ordinance explicitly places the burden of proof on the applicant. It also states that the requirements set forth below, including the requirements for DSPs, are the minimum requirements to be met. The zoning ordinance at its very top, section 102, lays out a number of public interest purposes. I would say the applicant hasn't met the minimum requirements. They haven't met the burden of proof that this project is in the public interest and that it meets the purposes that are laid out for the zoning ordinance or for DSPs. I think the place where I'm most disappointed is the argument, and it's the first time I've ever heard this argument in multiple cases, that the planning board is prohibited from considering off-site context or off-site impacts. That just makes no sense fundamentally, and there's nothing in the law that says that. And I would say again, the explicit requirement in the zoning ordinance that that a DSP be referred to the health department, and that requires the health department to conduct a health impact assessment. And then the definition of the health impact assessment is to look at the impacts and their distribution within the community. That fundamentally is a mandate to look at many of the very issues that we've raised repeatedly at these hearings. I know it's to Mr. Gibbs' advantage and his client's advantage not to do that, but that's what the law and common sense and good planning principles require of the department and the board and the applicant. And it just that burden has not been met. That explicit requirement has not been dealt with. The fact that the applicant and apparently the agencies have relied on obsolete queuing analyses is very telling. I believe I did put evidence in the record that that the literature shows that during COVID, the reliance on drive-through windows spiked and stayed high. It hasn't come down entirely post-COVID. And restaurants like this rely on perhaps half or more of their revenue coming through the drive-through service. You've got a facility, they want to make a profit. So they want to fill the parking spaces, and they want to move cars through their drive-through window. And a traffic analysis and air pollution analysis there's no air pollution analysis in a community that already has elevated levels of traffic-related air pollution and asthma, and a lot of kids under 5. An analysis that ignores those realities ignores the public interest and the impacts on the surrounding community. And you will see, and I hope I can trust that you will take very seriously the evidence that we put in the record around the deficiencies analysis, but also the context in this community. This community is overburdened already in so many ways. And I know this is just one drive-through fast food joint, but it's one of many that keep getting placed in these communities with no analysis of their impacts on the communities. And we can't say that we care about public health, or that we care about climate change, or we care about poor nutrition in so many of our communities, and we care about walkability if we're going to keep approving facilities like this. If there's any place where these kinds of analyses should be done and these issues should be considered, it's with a project like this in a community like this. And I appreciate, we all appreciate the planning board has continued this case and looked at some issues. I think, though, that fundamentally the narrowing of the funnel to the point that we're talking about whether or not there will be posters in the restaurant or a marker outside, these are serious. That's a very serious issue to be addressed, but that's what we're talking about on the final day. And the applicant is telling us that they relied on obsolete queuing analyses for their on-site traffic and bike ped circulation. It's kind of telling. So I would trust that you will look very seriously at the information we put on the record. I put on information on the record that shows that even the higher intensity 100-year storm that they designed for that's already obsolete based on NOAA's data and projections. And that, we're all concerned about climate change. And if we are concerned, we need to start looking at these realities really hard. And that's it. Thank you very much. I appreciate your time.
Thank you, Mr. Smith. Commissioners, questions for... I'm sorry, no questions. That's a summation by the opposition.
Chair, I believe someone else wants to do a summation.
I think Mr. Boato was just congratulating Mr. Smith. Is that correct, Mr. Boato?
That is correct. Yes, sir.
Okay. All right. We'll turn to Mr. Gibbs for summation of the final word, sir. The floor is yours.
Yes, thank you very much, Mr. Chairman. Couple of things historically here to start out with. When we filed the original site plan in this case, we and all of this information is in the record. We did not propose taking any trees down in the rear of the shopping center. The revised site plan that proposed taking those trees down resulted from months of citizen outreach and requests made by individuals who live in direct proximity to the shopping center and who are here every day. That is the reason we took that burden on in an effort to address concerns that have been raised to us to somehow curtail the trespassing and the detrimental impact that has caused to patrons and the shopping center generally, and which was the subject of witnesses and the affidavit of the police officer, all of which is evidence in the case. During the course of the case, based upon comments made relative to trees not coming down, we determined to withdraw the departure application and go back to the site plan that we had originally started with. That led to the formal withdrawal of the departure on December 18th and the withdrawal of the alternative compliance on December 20th. And let me say that the alternative compliance application, we never wanted to file an alternative compliance application. It is just a necessary step. If you want to get a departure from the landscape manual, you have to file an alternative compliance request, and that's why that was in. So both of those were withdrawn. So what we're left with is, quite frankly, a very simple case. We have an existing shopping center of some 2,000 square feet, and the McDonald's USA, as a tenant in the shopping center, proposes taking down one building and replacing it with an eating and drinking establishment with drive-through, using the provisions of the prior zoning ordinance, which are allowed and permitted, and which made sense given the fact that the shopping center was built under the prior zoning ordinance. So we were dealing with the CSC zone, and an eating and drinking establishment in the CSC zone under the prior ordinance is a permitted use of right, subject only to the approval of a detailed site plan. And so that's all that is before the planning board at this point. Now, in terms of the criteria for a detailed site plan, and one of the comments was that the planning board is hung up on nuances and is not addressing the real concerns of the community. What the planning board is doing is following the law. The law is what governs the detailed site plan process, and that's contained for detailed site plans using the prior ordinance in sections 27-281 through 285, and with tangential reliance upon design criteria set forth in section 27-274 of the zoning ordinance. And it's important to look at that because there has been so much testimony from opposition here about, oh, you have to look at the purposes of the zoning ordinance in 27-102, and you have to look at off-site traffic. And those are not relevant criteria under the law for the review and action on a detailed site plan. Again, the criteria are very specific. Everything you find in those sections that I just quoted are focused on the site. Even the elements that you have to show on your detailed site plan, all focused on the site. Where's the landscaping? Where's the building? Where's the parking? Where are the drive aisles? Where's the loading going to be? How are you going to get to it? Those are the relevant criteria for the review and approval of a detailed site plan. And in this case, what do we have? We have a site plan that has been prepared, that both the applicant's experts and your staff, every referral agency on your staff, feels is in compliance and conformance with all ordinance criteria. We have expert testimony from Mr. Speech that he designed the plan in accordance with all relevant criteria. That is undisputed and unrebutted. We have testimony from Mr. Lenhart. He testified about traffic generation. He went beyond what he was required to do in an attempt to address other concerns. He actually did a subdivision analysis, even though he was not required to. Everything passed under the standards, the legal standards that are required to be applied. He also did a queuing analysis. And, you know, Mr. Smith comes in and says they're using obsolete data. He gives zero evidence for that assertion. Here's the reality of the matter. There's no queuing analysis required under the old zoning ordinance, but Mr. Lenhart went further and used the new zoning ordinance, which, by the way, is a post-COVID ordinance. And the post-COVID ordinance adopted by this county has a queuing standard, which we exceed. There is zero, not a scintilla of evidence in this record other than raw supposition and allegation that queuing would ever be a problem at this restaurant. Were the allegations of the opposition to be given credence here, there wouldn't be a drive-through that would be approved in this county. And in fact, this board approved one for one of my clients last week on the 9th. I mean, every drive-through restaurant has queues. But the natural impact is that if people see a longer queue, they go into the restaurant. And the COVID issue, when we were in the depths of COVID, and the board can take judicial notice of this or administrative notice, you couldn't get into the inside of a restaurant. Everybody had to use the drive-through window. But we have a zoning ordinance that's post-COVID that has a queuing standard, which we exceed. We had the testimony of Mr. Mark Ferguson, an expert in the field of land planning. He summed everything up. He addressed the facts to the ordinance standards and found compliance. And then, of course, we have now 3 staff reports from the staff of the Maryland National Capital Park and Planning Commission, all of which find conformance, all of which included details and requirements which made the site design better, and all of which recommend approval. Not a single referral agency that this case was sent to recommended disapproval, including the Transportation Planning Division. So what we submit respectfully is that we have met the legal burden. I would like to say that in addition to the, we would proffer the historic condition that I discussed with Commissioner Washington, and I would also note that there were comments earlier at the November 21st hearing about trying to make this restaurant a destination. My client wants it to be a destination. That occurs, but what I can tell you is that representations were made by my client to the citizens during the numerous meetings that witnesses testified to, the consultant who had those meetings. They want the restaurant to become a destination. They want, even if necessary, for residents to be able to have meetings inside the restaurant. We proffered that, and we will continue to do that. But that's something that happens. We didn't feel you could manufacture that. But with all that being said, we fully believe that we've met all of the legal criteria for the approval of this detailed site plan. I think the planning board has certainly done everything possible to make this site plan better. I think that the inquiries of the planning board have resulted in a better plan, but the plan that's before us right now, we believe, meets all the safety concerns, promotes pedestrian safety through the site and pedestrian access to the site, as well as vehicular access and circulation on site. And so with all of that, we would respectfully request that the planning board approve this detailed site plan. Thank you very much for hearing me.
Thank you, Mr. Gibbs. All right, we have no one else. We've gone through our process. Commissioners, I'm going to close this public hearing. It is to us for deliberation and consideration of action. So, and let me just say, maybe there's an additional question or two that you might have for staff, which feels appropriate to me. But commissioners, let's open this up for deliberation.
I don't have any additional questions, Mr. Chairman, at this point.
Okay.
Yeah.
Nor do I.
Mr. Chairman, I have no additional questions.
Okay. All right.
Nor do I, Mr. Chair.
So let me just say before we consider action, this has been one of the more difficult cases that I've dealt with for a while, and in part because I am personally sensitive to the context issues. You know, it is a difficult intersection, and I am clear, as Mr. Gibbs laid out, and as our staff and our council, that you know, we work within our quasi-judicial role. So when I look at this, as frustrating as some elements can be, I think the facts are clear. And I think that we have, through this process, made it into a better project, but it's one that I feel like, you know, I don't see a reason to oppose this, despite the fact that it's a complicated intersection, but that's not what's before us. That's not what the DSP brings to us. We may or may not like that, but that is the reality of it. So colleagues, you know, I don't know where you're going to land on this, but even with some of these broader reservations, I think this process is made for a better project. And assuming that that's where you are too, I will be intending to support this. Any other thoughts, reactions, or is there a motion?
Mr. Chairman, I associate myself with your comments. And with that, and I would ask my colleagues to pay very careful, close attention to the motion I'm about to make. It's been a lot of paper, a lot of moving parts to make sure everything is included. With that, Mr. Chairman, I move that we adopt the findings of staff from the original staff report, in addition to the findings as amended by staff's first addendum, and findings as further amended by staff's second addendum. And with that, approve DSP-22001 and TCP2-004-2024 to include the conditions that are outlined in staff's original report, with the exception of conditions 1C, 2A, 2C, 3A, and 3B, in addition to the conditions as detailed in staff's first addendum, with the exception of 1B, 1C, 1D, 1E, 1F, 1G, 1H, 1I, 1J, and 1K, and the conditions as outlined in staff's second addendum, in addition to applicant proffered condition that, and I would ask staff and council to ensure the appropriate language, but that the applicant will work with the Historic Preservation Division to develop an external historic marker in addition to the interior education posters as described by the applicant on the record.
Second.
I think that's it. Okay.
I think so. Great job, Commissioners. Washington. Second, and I would just add, sharing the comments of Commissioner Washington, and I understand the question about the health issue. I've listened to a couple of podcasts recently about ultra processed foods and what it's causing. But unfortunately, at this stage, that's not something that we can consider. So I second the motion.
Thank you. We've got a motion by Commissioner Watson, a second by Commissioner Giraldo. Under discussion, the other thing I would add is just some things that I want to say for the record too, is that there were a few things that were brought up. That the stormwater management plan is something that's approved by DPI, so that process was in place, and the health department referral occurred as well. So it's not that these issues, for the public and for the record, it's not that these issues are ignored. They're just it is a process that occurs. Any further discussion on the motion? If not, I will call the roll. Commissioner Washington.
I vote aye.
You're on mute. Okay. Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Vote aye.
I vote aye as well. The ayes have it, 4-0. I want to thank everybody for a very lengthy, thorough, instructive, passionate process. So thank you, Mr. Smith, Mr. Boato, all the other folks who were part of that. Mr. Gibbs, thank you as well. Ms. Gomez, thank you, and the rest of the staff. Ms. Connor, any further business before us today?
Mr. Chairman, can you hear me, Mr. Chairman?
Yes.
Yeah, and this is the only I wanted to say publicly to Rhonda Ford and Jason Parsons, our technical writers, a big, huge congratulations and thanks. They often hear from me. I don't know if they hear from my other colleagues, sometimes late on a Wednesday night before hearings, but they are always there and they do a phenomenal job. I don't know if they sit in on this, but please share my sincere thanks to them for what they do on our behalf to get us ready for Thursdays.
No, that's a very, very much appreciate the kind words. I think Ms. Ford and Mr. Parsons, you're both on at the moment, aren't you?
Yes. Thank you, Ms. Washington. That was really nice. Thank you.
Oh, thank you. I'm so glad you were able to hear it. So,
if that was a motion, I would second it. It's not a motion. I agree. Thank
you. For Ms. Connor, any further business before us?
There are no further items. Thank you.
Okay, then without objection, colleagues, we are adjourned, and everybody enjoy the rest of the day, and we will see you all in a week.
Good luck in the new year, everybody.
Same.
Success to everybody.
Thank you.
And you, sir.
Bye-bye.
Thank you.
Y'all take care. Thank you. Bye-bye.